This matter comes before the court at this time for a scheduled pretrial conference. Mr. Patterson, what formal announcement is made at this time?
Your Honor, would announce this time there have been plea negotiations entered into. I did attempt to email to the court a signed defendant's acknowledgement of rights and entry of plea that also included the plea bargain that has been entered into in this case. And pursuant to that plea negotiations and plea bargain, I would announce at this time that Mr. Schroer is going to enter a plea of no contest to count 1, count 2, and count 4.
Guys, today we're diving into a courtroom twist that starts calm but hides tension beneath every word.
States agreed to dismiss counts 3 and 5.
That appears to be consistent with the document entitled Defendant's Acknowledgement of Rights and Entry of Plea, which this court received literally just before court started. Mr. Devaney, I trust that Mr. Patterson has announced consistently with your understanding as to how this case would be handled.
Yes, Your Honor. And I'd further note that the details of the plea, they're listed in the acknowledgement of rights and entry of plea document. We've discussed that. We also mentioned, because of the fact that this is a no contest plea, one of the things that Mr. Patterson and I discussed was that the court, at least there'd be stipulation to review of the affidavit as the factual basis. But if the court requires anything further, I'd be happy to provide any type of explanation with regard to those charges.
Well, the court was going to specifically direct that we avoid any reference to naming any victim in the case, that we refer to initials only. Is that a problem, Mr. Devaney?
No, not a problem at all.
Very well. Then that's what the court will direct.
Okay.
All right, Mr. Schroer.
Yes, sir. Yes, Your Honor.
All right, your attorney has made an announcement on your behalf that it's the court's understanding that you'd be entering no contest pleas to counts 1, 2, and 4 in return for the state's dismissal of the other 2 charges. Is that indeed your intention here today?
Yes, Your Honor.
Okay. Now let's clarify counts 1, 2, and 4. Count 1 would be aggravated endangering a child, a level 9 person felony. Count 2, also aggravated endangering a child, a level 9 person felony. And count 4 is Medicaid fraud, a level 9 non-person felony. Is that what you believe you're intending to plead to here today?
Yes, Your Honor.
All right. There are a number of questions I need to ask you regarding the taking of a felony plea. If along the way there is something that comes up that you do not fully understand, I will give you the opportunity to confer privately again with your lawyer, Mr. Patterson, before going any further. Just let the court know if you need that time to get some further advice. Okay, Mr. Schroer?
Yes, Your Honor. Thank you.
I want to have you start off by stating your full legal name for the record.
Joseph Schroer.
How old are you right now?
53.
What's the highest level of education that you've attained?
High school graduate.
Now, do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here this morning?
No, sir.
All right, Mr. Schroer, have you ever been adjudged to be mentally ill?
No, sir.
Are you under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
All right. Are you supposed to be taking any mental health medications that you are not currently taking?
No, sir.
So, Mr. Schroer, do you believe your mind is clear and that you have a full understanding of what's going on in court here today?
Yes, sir.
All right, Mr. Schroer, I trust that you've received previously a copy of the charges in this case?
Yes, sir.
All right. Do you understand the nature of the charge in count 1, aggravated endangering a child?
Yes, Your Honor.
Which, of course, is also the charge in count 2.
Yes, Your Honor.
Do you understand the nature of the charge of Medicaid fraud?
Yes, Your Honor.
Mr. Schroer, when you enter a plea of no contest, you are not admitting that you committed these acts, but you're also not contesting that you be convicted just the same. Do you understand that?
Yes, Your Honor.
Mr. Schroer, do you also understand that by entering pleas of no contest, you're giving up any legal defenses that you might have had to these charges?
Yes, Your Honor.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer at trial, and that you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, Mr. Schroer, you personally would have a privilege against self-incrimination, which means that if you wanted to testify in your case under oath, you could at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, Your Honor.
Sure, do you also understand that you have a right to a trial by jury, that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, Your Honor.
Sure, do you understand that you do have the right to appeal a guilty verdict if you have a trial?
Yes, Your Honor.
Do you further understand that you may appeal your sentence after entering pleas of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes, Your Honor.
Mr. Schroer, are you aware of the possible sentences that could be imposed as a result of these no contest pleas that you are attempting to make?
Yes, Your Honor.
Mr. Schroer, do you happen to have a copy of the non-drug offense grid under the Kansas Sentencing Guidelines Act before you here today?
I do, yes, Your Honor.
All right. All three of these charges are level 9 felonies. So if we'll look at the level 9 line, Schroer, follow along. If you
Yes,
look
Your Honor.
over at category 9I, which is the most favorable criminal history category, you could receive as little as a 5-month sentence for each of these level 9 offenses. However, if you look at the other end of level 9 in the worst criminal history category of A, you could receive up to a 17-month prison sentence for each charge. So the sentencing range is, for each of these 3 counts, 5 to 17 months in prison, depending on your criminal history. Mr. Schroer, as you said today, we do not know with absolute certainty what your criminal history is. You better than anyone else here should really know what your own criminal record looks like, but that will be researched by the Court Services Department, and based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 9 line, and then you'll be sentenced accordingly on the primary count. Do you understand that?
Yes, Your Honor.
Okay. You also understand that you could receive up to a $100,000 fine for each of these 3 offenses?
Yes, Your Honor.
Mr. Schroer, I need to point out to you that if you look at level 9, you'll probably see that categories C through I are shaded differently than A and B. If you fall in categories A or B, which means you have at least 2 person felonies on your record at time of sentencing, you would be presumptive prison in this case. Do you understand that?
Yes, Your Honor.
Mr. Schroer, do you understand the differences between concurrent and consecutive sentencing?
Yes, Your Honor.
Concurrent sentences all run together. When you're serving one, you're also serving a sentence on another charge or another case. Consecutive sentences are boxcard, back to back. You serve all of one before you start the other, obviously resulting in a longer possible sentence. You understand that, Mr. Schroer, generally it's up to the court to determine whether your counts run consecutively or concurrently.
Yes, Your Honor.
All right. In addition to any fines that could be imposed, Mr. Schroer, are you aware that you could be assessed and be required to pay court costs, certain fees, appointed fees, or certainly one of those other fees, and then restitution to victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also understand, Mr. Schroer, that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
Schroer, do you understand that both probationary and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, Your Honor.
Sure, do you also understand that the Kansas Sentencing Guidelines Act is much more than perhaps the grid page that you have before you? It's an entire book of sentencing rules and laws. Do you understand that if any special rules under the law apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence?
Yes, Your Honor.
Now, did you have an ample opportunity to discuss legal matters like that with your attorney, Darren Patterson, before proceeding here today?
I did. Yes, Your Honor.
You want any more time with him privately now before we go further?
No, Your Honor.
Are you satisfied with the services provided by your lawyer?
I am. Yes, Your Honor.
Now, this guilty plea that you're, no contest pleas that you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, Your Honor.
Is there anything else that you thought was part of the plea agreement that hasn't been accurately discussed on the record or covered by your written plea agreement document?
No, Your Honor.
Speaking of this document, as I referred to earlier, it's called Defendant's Acknowledgement of Rights and Entry of Plea. Have you fully read it?
Yes, Your Honor.
Do you fully understand its contents?
Yes, Your Honor.
And I'm looking at the last page of it, Mr. Schroer. It appears to bear your signature, though I have a little difficulty reading it, not unusual for signatures. Is this indeed your signature on this document that I've referred to?
Yes, Your Honor, it is.
All right. For sure, do you understand that if there have been any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir. Yes, Your Honor.
Mr. Schroer, let me ask you, how do you formally plead to the charge in count 1, aggravated endangerment of a child?
The darkest turn in the entire hearing. A child locked in a basement closet, no food, no light, and a cover-up tied to stolen Medicaid funds.
No contest.
And to count 2, aggravated endangering a child?
No contest.
And to count 4, Medicaid fraud?
No contest.
All right, again, referring to any victim information by initials only, Mr. DeVinny, I'm going to ask the state's attorney to provide a factual basis for each of these 3 charges.
I can do so, Your Honor. Again, Mr. Patterson and I had discussed this and has suggested stipulating to the admissibility of the affidavit for the court's review for the factual basis. But if you deny that request, then I'd be happy to do so. But
the court denies the request.
Okay, very well. The first event occurred, it was June 5th of 2023. The victim, VBS, child in the home. The state's evidence would show that between Mr. and Mrs. Schroer, that they had basically had an organization where Christina would notify Joseph or monitor what was going on in the home. And particularly on for count 1, June 5th of that year, VBS was placed in a closet in the basement. It's a very small closet, Your Honor. And that was a form of punishment. There was communications made between Christina and Joseph at that time to keep the child inside this closet. There's no bathroom facilities in the closet, anything like that. And actually, some of the communications made were the fact that the child had been tearing up the carpet, the floor, and the basement. But this child, as a form of punishment, was placed, like I said, in a darkened closet and was told not to leave that room. And I think that is the basis, really, for the state's charges for count 1, aggravated endangering a child. It was a limited space. There were, like I said, no facilities or anything like that. And the child was placed for an extended period of time in this closet. This wasn't just a timeout situation or anything.
So the
Communication.
state's evidence would show that this child's health was endangered by this situation?
Absolutely. Food was limited, and again, restricted from bathroom facilities or any hygiene facilities at all during this period of time in which the child would be placed in the closet.
And count two, Mr. Devaney?
Compared to count two, same situation, just on a different date. It's June, I believe, 14th of 2023 is the count two. And it was the same incident, same type of facility. It was that we need to lock the door on the closet. And again, VBS, the child in question, was questioned by, and this was made known to Joseph that the child was supposed to be back in the closet. That Christina had looked at the internal monitoring of the home and seen that the child was out of the closet. And so there were communications made between Christina and Joseph both to return the child back to the closet. And it's the same spot in the basement, same situation. There's no food was restricted, no bathroom facilities, etc. And that she had once again returned to this small enclosed space for an extended period of time on that date of June 14th, 2023.
Very well, Mr. Devaney. Factual basis for count four?
With regard to the Medicaid fraud, Your Honor, the child that was subject to the benefits, and that is to say that Christina and Joseph, this married couple, received additional Medicaid benefits. This was a child who was adopted, and so there were not only state subsidies, but there were also Medicaid subsidies that were provided as a result of this. This child was deceased, and they failed to report this child as being deceased, continued to receive the benefits, and it went on for an extended period of time. Specifically, that count, Your Honor, for Medicaid fraud, I think the affidavit reflects about $3,800 in additional benefits for Medicaid fraud. But part of the agreement here that we have with regard to counts 3 and 5 is a restitution amount for also the state subsidies as well. And so the restitution amount that we eventually yielded for this case was an amount almost close to $27,000 between for this child, whether it was state or federal Medicaid benefits or adoption subsidies. And so as a result, our plea agreement reflects that additional or higher amount of restitution. And so the state's actually requesting a restitution amount as a condition of this plea for Mr. Schroer of $13,413.82. That is contained in the plea agreement. But the Medicaid fraud in particular was approximately $4,000 of that total amount of $27,000.
Yet the acknowledgement of rights and entry of plea agreement suggests that the restitution amount is $13,413.82, far short of the total amount of damages that you just referred to. So
it's half, Your Honor, and maybe this wasn't clear in our plea agreement, but we had half of the restitution to be paid by Christina Schroer. And I wanted to make sure that on her case, which she's already pled and awaiting sentencing. But what I'd worked out with counsel in both cases was that they would pay 50% of the restitution and be separated. The reason I did that, Your Honor, is because these parties are in the process of a divorce, and I think they both bear the burden, not only of the financial recompense in this case, but I didn't want, as a condition of a divorce or something like that, for one person or one party to end up having to pay all of it on behalf of the other party, because the state has an interest in making sure that they're both accountable. So I divided that restitution figure in half on Christina's case, and the other half was reserved for the ongoing plea negotiations I had with Mr. Patterson with regard to Joseph Schroer.
very well. Court accepts the statements of factual basis from the prosecuting attorney. And I'll turn back to Mr. Schroer and ask, all right, Mr. Schroer, at this time, are you making pleas of no contest and accepting conviction for counts 1, 2, and 4 freely, knowingly, and voluntarily?
Yes, Your Honor.
Mr. Devaney, as prosecuting attorney, do you know of any legal reason why the court should not accept Mr. Schroer's pleas?
I do not, Your Honor.
Mr. Patterson, as defense counsel, are you aware of any legal reason why the court should not accept your client's pleas?
No, Your Honor.
All right, Joseph Schroer, I'll ask you, do you know of any legal reason or any other good reason why the court shouldn't accept your pleas of no contest here today?
No, Your Honor.
Court will accept the no contest pleas made by the defendant, finds that those pleas are made voluntarily. He has an understanding of the nature of the charges against him and the consequences of the pleas, and a factual basis for each plea does exist. The court finds the defendant guilty pursuant to the court's acceptance of his no contest pleas, and adjudges him therefore convicted in count 1 of aggravated endangerment of a child, a severity level 9 person felony. Also count 2, aggravated endangering a child, a level 9 person felony, and count 4, Medicaid fraud, a level 9 non-person felony. The other charges of the information are dismissed pursuant to plea agreement. The court orders a pre-sentence report be prepared and completed to accurately determine Mr. Schroer's criminal history, and the court will set an appropriate date for sentencing. Mr. Schroer, as I'm sure your attorneys pointed out to you, that there is a legal requirement of a pre-sentence investigation and research of your criminal history, and it takes a certain amount of time.
Yes, Your Honor.
And so we generally set your sentencing out about 8 weeks from the time of the plea to allow this process to take place. So we
Yes,
will
Your
be
Honor.
looking for a date in early December for sentencing in this matter. Mr. Patterson, would you check your calendar for the morning of Wednesday, December the 3rd? And I'm looking at an 11 o'clock a.m. time slot.
11 o'clock works fine, Judge.
That will be an in-person sentencing. Butler County Judicial Center, El Dorado, Kansas. Mr. Schroer, you are ordered to be in courtroom B at the Butler County Judicial Center at 11 o'clock a.m. Wednesday, December the 3rd. And in fact, I would recommend that you come about 15 minutes early to get checked in through security and get to the right place. And in fact, your attorney may need to meet with you for a few minutes before the sentencing starts. But it's the court's intention to start the in-person proceeding Wednesday, December 3rd at 11 o'clock a.m.
Yes, Your Honor.
Mr. Schroer, you may be asked by the Court Services Department as part of the pre-sentence investigation process to complete one or more assessments, such as a risk needs assessment. The court orders as a condition of your continuing bond to cooperate fully with the Court Services Department and complete timely any pre-sentence assessments or evaluations that they request of you. Do you have any questions about that?
No, Your Honor.
Furthermore, I'm going to want Mr. Schroer to contact the Court Services Department immediately after this hearing. Mr. Patterson, are you in a position to make a call to that office?
Judge, I anticipated walking across the street with my client to their office.
Even better, Mr. Patterson. So, Mr. Schroer, Mr. Patterson knows where the Court Services office is, and he'll walk you over there and you'll make your first contact with that office. Follow any scheduling or other direction that that department gives to facilitate this pre-sentence report process.
Yes, Your Honor. Thank you.
Okay. Now, Mr. Devaney, are you aware of other matters that the court still needs to address as part of today's proceedings?
I do not, Your Honor.
Mr. Patterson, are you aware of anything further?
No, Your Honor.
All right. Mr. Schroer, is there anything that you need to address the court about today?
No, Your Honor.
Okay. Obviously, this case is taken off next week's trial docket in light of this resolution of the case by plea. If there's nothing further in the Schroer matter at this time, the court will be in recess, and this meeting may be ended for all.
The judge accepts the plea, reads the convictions, and sets the sentencing. Joseph's fate is sealed, his quiet "Yes, Your Honor," echoing like a full stop to everything he built. If you found this breakdown powerful, like the video, subscribe to the channel, and we'll see you in the next one.